Thank you very much for coming to this private client breakfast briefing. We've got 4 short talks lined up, and we're going to start off with Lemuel talking about problems with formalities. A regular problem and one which sometimes our commercial clients look down on private client lawyers, but when it comes to actually making sure that something's a deed, they have to turn to us. So, Lemuel.
Excellent. Thank you, Robert. So, in a tax planning context, one of the first things that I think it's probably best to do is to double check to see if the formalities have been followed. That's because if they haven't, and it's to your client's benefit for the scheme to be ineffective, or at least the transfer of the property to be ineffective, you don't need to bother about rectification, rescission, all of those discretionary judgments of the court. You can just say, sorry, whoever advised on this screwed up. Hopefully it's not you, obviously, and therefore it's not effective. Now, in the tax context, this can be a little bit odd in that you obviously need to first check, is it better for it to be void or is it better for it not to be, in terms of where you want to kind of nail colours to the mast. But even if it's better for the transfer to be effective, you still got to make sure that it actually was. In my experience, particularly with clients who say their main asset is the family home or something similar, the advice they've taken on tax planning has often not been particularly good. And therefore, there's quite a strong chance that if the transfer is ineffective, it's better for them because they've not done it right. They've not, they'll fall subject to the reservation of benefit rules or whatever. I had one recently where they were trying to get interest relief, but had just royally screwed it up. And I said, well, you didn't actually transfer any of the properties anyway, so you have some back taxes to pay, but perhaps that's better, but ask an accountant to do the maths. So there are 4 particular requirements that I think it's useful to talk about today. So the first one is Section 2 of the Law of Property Miscellaneous Provisions Act 1989. That, in a nutshell, provides the contract for sale or disposition of an interest in land can only be made in writing, and it must incorporate all the terms which the parties have expressly agreed in one document. You can also exchange contracts to do it that way too. The terms can be incorporated through a different document, but you've got to say this contract or deed is subject to or incorporates all the terms. You can't just say there's this other document. You've got to be quite specific, and it's got to be signed by both of the parties. Then you've got Section 53(1)(a) of the Law of Property Act 1925, which is that no interest in land can be created or disposed of except by writing, signed by the person creating or conveying the same. In practical terms, this has such a high level of overlap with Section 2 that you're probably unlikely to be relying on it separately, but we'll come to that a bit later. Then you've got Section 53(1)(b), which provides that a declaration of trust must be manifest and proved by some writing signed by the person able to declare. And then finally, Section 53(1)(c), which is that the disposition of an equitable interest must be in writing. Although the rest of Section 53 applies only to land, 53(1)(c) applies to equitable interests. Generally, everyone had presumed it applied to equitable interests generally for a few hundred years, but there was no case on it until very recently in the Supreme Court in Slingo and LA Micro Group, where the Supreme Court said yes, or I suppose to be more accurate, they said everyone's assumed it has for so long, we'll just leave things as they stand. In each situation, you might be able to fall under the saving provisions because in all of these, they are unaffected. They do not affect the operation of resulting, implied, or constructive trusts. And unless you can say that a constructive trust arose, in each case, the transaction is void and of no effect. So there's then three things that I think it's worthwhile to consider. I'll delve into the formalities themselves in a bit more detail, how you might want to go about trying to save the failure by a constructive trust, although spoiler alert, it's going to be quite difficult. And then thirdly, something which hasn't yet been the subject of any particular decisions, but I think is probably likely to come up the first time someone tries to argue in court that the transaction they did is void, namely whether there might be some sort of bar on that because of public policy reasons or some sort of estoppel principle. So going back to the beginning and section 2, law of property miscellaneous provisions, it's important to be clear that section 2 bites on the contract and the terms. So it's not talking about the TR1 itself that conveys the interest, or potentially the lease document itself which creates the interest. It's the contract whereby the agreement to give that interest was made. So for example, a TR1 isn't normally going to give you anything about the deposit provisions or anything similar, and therefore doesn't actually give you the full terms of the contract under which the interest was transferred. It's just going to be creating the interest itself. One of the big danger of section 2 is that you have to include all of the terms. And that means if you've got an otherwise valid contract that has missed something out, if the court finds that it's missed something out, even though everything was properly executed and done very well, your transaction is still void, even though everything else has been followed to the letter. It's a very blunt instrument piece of legislation. So the main case on section 2 in the tax context is still Shelford and HMRC, which I suspect all of you have been told about ad nauseum since it was decided in 2020. But the court there found that because there was a failure to comply with section 2, the property had remained part of the taxpayer's estate rather than going outside. Now, I suspect most of you will be pleased to know we're not going to go into great detail about why that was bad, partly because it's my policy not to talk detailed tax things before 9 o'clock. So we'll just skate through in brief detail. So there, Mr. Herbert, who was the taxpayer, who was then deceased, tried to implement a tax planning scheme, which was known as the home loan scheme. Essentially, that meant the property would fall outside of his estate and hopefully not be subject to IHT. In this case, that was done by the property being sold to a trust, which borrowed the purchase price from Mr. Herbert. The benefit of the loan from Mr. Herbert to the trust was then assigned to Mr. Herbert's children. No money actually changed hands. The trust would never have had any money to actually make the payment of the purchase price either. It only ever had £10 and then had the property transferred to it. The sale agreement itself mentions that the loan agreement existed, but it didn't on its terms say that the sale was contingent on the loan taking place, or say that the consideration was the loan or anything similar. So because of that failure of the terms of the agreement to spell it out, the judge found that the sale agreement and the loan agreement were really a composite agreement. So all of the terms needed to be included in at least one of them for section 2 to apply. And further, that the actual agreement was that Mr. Herbert had sold his property to the trustees, but with completion to occur and consideration to be paid following his death, which was not what the terms of the sale agreement said. There are also various other terms, such as, for example, it said that the buyer would then be entitled to immediate vacant possession. Mr. Herbert, as the seller, remained in vacant possession all of the time. And essentially, the contracts just weren't particularly well drafted. So because the contracts didn't say that completion was to occur after death or the consideration to be paid after death, it was void. Moreover, even if the contract had properly incorporated the loan agreement, because the loan agreement itself didn't reflect the true agreement, that wouldn't have saved them at all. So another thing to note for section 2 is that rectification to bring things within the ambit of section 2 is very limited. This hasn't been updated in light of Pitt and Holt, so query whether there's a small chink of light, but at least the current authority, which is Un v Ahmad, is that you can't have rectification just to fall in terms of section 2, unless you can point to a particular mistake about the contract itself rather than the legal consequences of the document. So if the parties have just misunderstood that it was valid, that's not enough. But if there were genuine terms that they had intended to put down in writing, then perhaps you can have rectification. Where obviously the parties don't want to put something in writing, you can't have it. And there is the reason given for that is that otherwise you undercut the policy considerations of the statute. Parliament has said it's void, so you better have a jolly good reason for it not being void. So for 53(1)(b), which is that a trust must be manifest and proved by signed writing, the main thing to remember here in terms is that it can be sometime after the trust itself has actually been declared, because it's a proving requirement, not a declaration requirement. So for example, in Taylor and Taylor, there was a notice of severance which was signed by both parties that recorded the existence of the trust, and that then meant it was therefore manifested and proved. And in this context, as soon as the trust is manifested and proved, it gets validated back to the beginning of its existence. So in this, that means that obviously if the planning is mainly just the trust, it's quite critical for clients to look through all of the documents that they have, because if they've been dealing with the property on the basis that the trust does exist, there's at least a chance that actually something has been signed, which means even if the trust hadn't been validly declared in the first place, it certainly is now, and then you are in the context of rectification or rescission. And then finally, on section 53(1)(c), this rarely is going to come up unless you've got subtrusts or a separation of the interests. But one of the big things to note after Frenkel is that if you've got a vendor-purchaser constructive trust, that will avoid the need for the formalities. But to note there is that a vendor-purchaser constructive trust can't arise unless you can get specific performance, and that requires a valid contract. So if there's been a breach of section 2, you don't get your vendor-purchaser constructive trust in the first place. So in terms of the constructive trust, the FTT will take these into account if they can be established on the evidence. So that was done quite recently in Ravindran and Revenue HMRC, where a deceased estate was not liable to CGT because a brother proved during those proceedings that the property beneficially belonged to him. But in reality, for a lot of tax planning, you're likely to struggle in proving the elements needed for a constructive trust. That's partly because you've got the authority of Cobb and Yeoman's Row, where essentially the House of Lords poo-pooed the idea that you can have a constructive trust to fill in the gaps for a failure of formalities in a commercial transaction. And that is still good law, and in particular, where an agreement is intended to take effect only where it's signed, no one can rely on a constructive trust anyway. Even when you get into the exact specifics of a constructive trust, you've got to establish detriment on the part of the transferee. And in my experience of the tax planning cases, that's likely to be somewhat difficult, because often the transferor, who is normally the taxpayer, has taken actions on the basis of the planning that they thought they had done, but the transferee themselves, sometimes less so. But again, it's going to depend on the specifics of the situation. And also the detriment is going to be key, because that's still a strong requirement following Hudson and Hathaway, as we've been reminded. Even if you've got through on detriment, you've then got the open-ended question for a constructive trust, assuming you want to make sure the transfer was effective, that it's got to be inequitable for the transferor to deny the rights of the transferee. And that's difficult here, because in a lot of the tax planning cases, economically, you've got the same actor on both sides of the transaction. And then you are much more likely to be not quite throwing yourself on the court's mercy, but you've got to be persuading the court that actually, yes, it was inequitable in all the circumstances. Now, as we're going to come on to here a bit later, even the fact that this was intended as a deliberate tax avoidance scheme isn't going to be a bar, because of course you've not yet taken that sort of approach, but it is going to be a little bit difficult in showing that it was unconscionable. And then finally, you can rely on proprietary estoppel in this sort of context too, but again, you're going to have to establish all the elements of that, which is likely to be difficult. So if you want to rely on a scheme potentially being void, the open question, at least posed by some people, is can you? So far in Shelford, it was HMRC who were arguing that it was void and the agreement was invalid. But there may be cases where it's actually in the taxpayer's interest to say, no, this didn't work, my advice was wrong. So far, we haven't had any judicial pronouncements on this. My money is on that there shouldn't be any bar to it, partly because the reason we have these formality requirements is because Parliament has made the public policy decision that this is where the line should be drawn. There isn't, although there is some perhaps public policy against allowing overly aggressive tax avoidance, depending on who you ask and which judge you're before, that isn't the same as having a policy in holding people to void agreements that do not have force of law. The point of formalities is you have a principled approach. So if a transaction being void could result in more tax being paid, you should also have the option where if a transaction is void and less tax is paid, that's simply the true answer to the decision. Obviously, the important thing to bear in mind there is that if you're saying it's void because it was failure to sign or similar, HMRC are likely to scrutinise that in quite a lot of detail. And the court itself, although it shouldn't decide against you on general discretionary grounds, is probably going to give taxpayers a very short leash in terms of needing to say categorically that these things weren't signed and chapter and verse on that, and really interrogate the evidence about what was done, perhaps in case HMRC are the ones who want to allege a constructive trust arose. So yes, that's formalities, and obviously if your formalities have all been tipped and you still want to get out of things, then you might look at rescission. So in that case, Ben's going to tell you about rescinding for mistake.
Thanks, Lem. To start at the very beginning, where a trustee has made a mistake, the court may rescind or rectify the exercise of his or her power. Such relief can be extremely desirable, not least where the original exercise of the power entails unpleasant tax consequences. That's essentially why we're here this morning. The leading authority on when a mistake will count and relief will be granted is, of course, the Supreme Court's judgment in Pitt and Holt. According to Lord Walker in Pitt, there must, 1, be a mistake, 2, of sufficient gravity, such that 3, it would be unconscionable for the beneficiary of the transaction to oppose reversing the transaction. As that summary implies, the first question to ask is whether there's been a mistake at all, or whether the trustee has gone wrong in an ostensibly similar but legally distinct way. And one crucial difference here is between a mistake proper and what the authorities call a misprediction. Lord Walker acknowledged that distinction in Pitt and Holt, and in doing so, he cited the case of Dextra Bank and Trust Co. Limited and Bank of Jamaica. He said that was the first case in which the concept of misprediction had received judicial currency. In Dextra, which was a commercial case, the court quoted with approval a passage from Peter Burke's book, Introduction to the Law of Restitution. And this passage explains what the difference between a mistake and a misprediction is, and further explains why relief should be available in respect of a mistake, but not a misprediction. I'll just quote briefly. The reason is that restitution for mistake rests on the fact that the plaintiff's judgment was vitiated in the matter of the transfer of the wealth to the defendant. A mistake as to the future, a misprediction, does not show that the plaintiff's judgment was vitiated, only that, as things turned out, it was incorrectly exercised. A prediction is an exercise of judgment. To act on the basis of a prediction is to accept the risk of disappointment. If you then complain of having been mistaken, you are merely asking to be relieved of a risk knowingly run. That was Peter Burke's explanation of the basis of the distinction. And the Court of Appeal recently distilled that same point in the case of Bauer and Equity First Trustees Nevis Limited, a 2023 case about mistake which was in a trust and tax context. The Court of Appeal said that one can justify the refusal of the law to intervene in a case of misprediction by pointing out that a mispredictor can generally be viewed as a conscious risk taker who assumes the risk of his speculation proving to be incorrect. I'll come back to the Bauer and Equity First Trustees case a bit later on. So the distinction between mistake and misprediction makes sense at a basic level. In certain cases, however, it can be hard to know where to draw the line. As Lord Walker acknowledged in Pitt, a telling example is the case of Inri Griffith's decease from 2009. In that case, Mr. Griffith settled shares on trust as part of an inheritance tax planning scheme. The full benefit of the arrangement would only be realised if he survived for 7 years afterwards. The transaction was done in 3 stages, the last of which was in February 2004. Mr. Griffiths was then diagnosed with lung cancer in October 2004 and died in April 2005, well within the 7-year period. At first glance, one could see this as a classic case of misprediction in the sense I've been outlining. Mr. Griffiths calculated that he was likely to live out the 7 years, but his calculation was wrong. Yet on the evidence, Mr. Justice Lewison found that at the last stage of the transaction in February 2004, Mr. Griffiths was actually already suffering from undiagnosed cancer. That meant that he'd made a mistake as to his present situation at the time of the transaction, and that in turn made the transaction eligible for relief as a mistake. Commenting on Griffiths in Pitt and Holt, Lord Walker noted that the claim was a hair's breadth away from failing on grounds of misprediction. In the Court of Appeal's earlier judgment in Pitt, Lord Justice Lloyd had said it was strongly arguable that Mr. Griffiths was the sort of risk taker whom the category of misprediction was intended to catch. The closeness of the shave in Griffiths, as reflected in those comments, was essentially the result of the particular facts and the inconclusive expert evidence adduced as to Mr. Griffiths' illness. One can imagine all sorts of similarly tricky edge cases, but the problem would always, in essence, be a forensic one of that kind. Yet it could also be argued that there's a deeper ambiguity in the distinction between mistake and misprediction, and that's what I'm going to explore next. To explain this point, we first need to return to the Bauer and Equity First Trustees case from 2003, which I mentioned earlier. Mr. and Mrs. Bauer transferred their substantial property business into an employee benefit trust via a series of transactions on very bad advice, as it happens. The Bauer's aim was to avoid inheritance tax while continuing to benefit from the relevant assets. After HMRC challenged their tax avoidance scheme, the trustee of the Employee Benefit Fund took steps to collapse the trust entirely and distributed all the capital to the NSPCC. I mean, it's fair to say that's not at all what the Bauers originally had in mind as the ultimate outcome. And so they applied to have their original transfer of the business rescinded for mistake. At first instance, Mr. Justice Marcus Smith dismissed the claim, and one of his reasons was as follows. He said, "I accept that Mr. Bauer and the Bauer family miscalculated in terms of the consequences to them if the scheme went wrong. He held that this was not a mistake, it was a misprediction." And the point here has an intuitive appeal. The consequences of a decision follow from it. At the time of the decision, they lie in the future. So an error about them, you might say, is a misprediction, according to the reasoning I went into earlier from Peter Burke's and the Dexter case. Yet on appeal, the Bauers argued that they were wrong about the immediate tax consequences of their transaction, and that this was a mistake and not a misprediction as the judge had held. The idea seems to be that the word, behind the word immediate, seems to be that some consequences are intrinsic to the decision itself at the time it's made, whereas future matters, one merely predicts, are somehow more remote than those immediate consequences. So what to make of these rival arguments? As Lord Walker noted in Pitt and Holt, a crucial authority on mistake as to consequences was for a long time the 1990 case of Gibbon and Mitchell. In that case, Mr. Justice Millett, as he then was, had distinguished between two things. The first was mistakes as to the effect of a transaction, and the second was as to mistakes as named by entering into it. A mistake as to the effect, Mr. Justice Millett said, was a qualifying mistake, but a mistake as to the consequences or advantages of the transaction was not. There'd be no relief there. And Gibbon, of course, was decided before the Dexter case, so the concept of misprediction as such was not yet on the scene. Nonetheless, one could fold Gibbon into the mistake versus misprediction framework fairly easily. The effect of the decision is arguably a matter of the decision itself in the present, whereas the consequences are arguably down the line in the future. A calculation as to the advantages to be gained from a transaction, which the judge grouped with the consequences, could be said to involve the sort of exercise of judgment that Professor Burke's associated with misprediction. So that's one answer to this consequences question that you could adopt. But the Supreme Court in Pitt and Holt took a different approach. Lord Walker said that the distinction between mistake as to effect and mistake as to consequences wasn't very helpful after all. Gibbon's case could not be affirmed. Rather, the true requirement is simply that there be a causative mistake of sufficient gravity. The most one can say is that a mistake as to the essential nature of the transaction is more likely to be more serious than a mistake as to its consequences. In principle, there's no reason a mistake as to consequences can't count if it's serious enough. And importantly, Lord Walker did not directly address how a mistake as to consequences might relate to a misprediction or miscalculation as to the future. Indeed, he dealt with misprediction and mistake as to consequences in separate parts of his judgment. In his view, the latter issue related not to whether there had been a mistake at all, but to whether the mistake was sufficiently serious. So this was the backdrop for the Court of Appeal's judgment in the Bower case. As I explained earlier, one ground of the Bower's appeal was that the judge had been wrong to equate a mistake as to the consequences with a misprediction of the future. And so how did the Court of Appeal resolve this issue in light of all the matters I've been outlining? At first sight, you could say its approach was disappointing. Lord Justice Snowden said that he could see both sides of the argument and that it was not necessary to resolve this interesting point in the instant case, something we very often hear. That is because even if the judge was wrong, and this was a case of a mistake rather than a misprediction, the reasons that follow, I would still be of the view that relief should be refused when the remainder of Lord Walker's analytical framework in Pitt and Holt is applied. In other words, the Court of Appeal ducks the question I've been asking. Yet the Court of Appeal's actual reason for dismissing this ground of appeal is nonetheless interesting. According to Lord Justice Snowden, the key point is that Mr. Bower knew that there was a risk that the scheme would not work, i.e. that it could be successfully challenged by HMRC. For this reason, the judge said, it would not be unconscionable for the transaction to be left undisturbed. The fact that the transaction was part of a deliberate tax avoidance scheme strengthened the court's conclusion on this unconscionability issue, but the risk-taking point was a freestanding one. So, standing back, where does that leave practitioners now who wishes to have an exercise of power rescinded on account of its tax consequences? Well, right at the start, I mentioned the sort of three parts of the test from Pitt and Holt: mistake of sufficient gravity such that it would be unconscionable for the beneficiary to oppose reversal. And what comes out of the authorities I've considered is that each of those three elements of the test could constitute a linked but separate hurdle to getting relief. Firstly, it might be argued that the error as to the tax consequences of the transaction was not a mistake at all, but rather a misprediction as to the future. That's what the High Court held in Bower, and what Snowden LJ declined to reject on appeal, leaving it open. Secondly, it might be argued that a mistake as to the tax consequences of the transaction is not sufficiently grave to warrant the court's intervention. Lord Walker warned in Pitt and Holt that mistakes as to consequences were less likely to meet the standard. Thirdly, it might be argued that a mistake as to the consequences involves a calculated risk as to how things will turn out, even if it's not a misprediction in the strict sense, and even if it is palpably grave in its consequences. That's how the Court of Appeal justified refusing relief in Bauer. So essentially, you have to sort of clamber over all those hurdles, and the concept of misprediction as such is, in a way, only the start of your problems.
Thank you, Ben. Good morning, everyone. It was once put to the great physicist Albert Einstein, by his accountant as it happens, that the hardest thing in the world to understand was his theory of relativity. It said that in hearing this, Einstein paused, he furrowed his brow, scratched his head, and then responded that this was not correct. The hardest thing in the world to understand, he said, was income tax. Now, the focus of this morning's session is not a specific tax, but a variation on Einstein's furrowed brow and head scratching relevant to today's discussion. Is perhaps the question one often hears asked in the context of cases involving the state. What position or approach is the revenue likely to take in relation to this sort of tax pattern? Or a variation, what position or approach is the tax tribunal or an upper appellate court likely to take? Having done work for taxpayers and for the revenue over the years, and having spent a fair amount of time litigating in the tax tribunal and beyond, I hope I'm in a position to say a little on this topic. Of course, in a sense, it's huge, but with limited time and with the warning from Robert that there'll be severe discipline if I go over. I'll keep things simple. I'm going to make 4 points. The first concerns legislation, the second, facts, the third, settling with the revenue, the fourth, tax avoidance. First point, focus on the statutory provision. In considering mistaken transactions or dispositions and their tax consequences, a good deal of time is often spent, and rightly so, on analysing how particular equitable doctrines might map onto the situation. However, I would suggest that it's also worth bearing in mind that when it comes to the revenues approach, in my experience at least, it tends to be very much statutes provision focused. That's not to say principles and doctrines that emerge from the case law are to be disregarded. They're not. But it is to say that the particular charging provision within the particular tax statute is likely to have primacy, or at any rate, centre stage role to play in the revenues analysis and approach. That in turn, in my experience, tends to be the approach that one sees adopted in the tax tribunal, where appeals in respect of amendments to returns are first litigated. Indeed, even once one gets beyond the tax tribunal, up to the Court of Appeal and above, where the contours of doctrines are sharpened, the specific statutory provision is still key. It all depends on the construction of the provision in question. Supreme Court, UBS, para 65. There can be no substitute for a close analysis of what the statute means. Barclays Mercantile, paragraph 38, House of Lords. To illustrate the point, let me flag briefly one example. This is dealt with excellently by my good friends and colleagues, Michael Furness KC and Tiffany Scott KC. Good morning, Tiffany. In an article called In the Post-Pitt World, which one can find on the Wilberforce website and elsewhere. It concerns the word payment. The word payment is one which appears in various taxing statutes, and questions regarding payments are often in point in relation to mistakes. Why was a certain payment made? What does the payment actually mean in this context? Is it necessary for legal and beneficial interest to pass in order for that money transfer to constitute a payment? When does a charge of tax in relation to any purported payment arise? What the case law brings out is that the answer to these sorts of questions may turn on fine points of statutory construction. Take the Income and Corporation Taxes Act 1988, ICTA. It's the act which, among other things, contains the taxing regime in respect of approved pension schemes prior to the Finance Act 2004 coming in. And if you were to look at the adjacent provisions of 600 and 601, you would see the word payment. A search of the case law will reveal that the word payment has a different meaning in each of those two sections. Section 601 deals with, among other things, the situation where an employer under an exempt scheme is permitted to receive a payment in relation to a surplus. In the case of Hillsdown, 1999, where a payment had been made to an employer in breach of trust, such that beneficial title did not pass, and the employer had to hand the money back. Mrs. Justice Arden, as she then was, held there'd been no payment for the purposes of Section 601 at all. As she put it, there's no reason in the present case why Parliament should seek in Section 601 to tax a payment which was not effectively made. So we've got this notion of an effective payment. Contrast that with Section 600 in the later case of Venables and Hornby, 2002. In contrast to Section 601, 600 focused on unauthorised payments rather than authorised payments. The submission was advanced that because on the facts the payment in question had been made in breach of trust, it followed that there was no real or effective payment in a Hillsdown sense. Ergo, no charge to tax arose. In the Court of Appeal, Lord Justice Chadwick, in a characteristically certain fashion, thought that this argument was, quote, plainly untenable, where the purpose of the section was to deal with unauthorised payments, i.e. payments that were or were likely to have been in breach of trust. He reasoned that to hold that there'd been no payment because the monies paid remained subject to the trust of the scheme would be to defeat the obvious purpose of the taxing provision. So, two decisions on consecutive sections in the same act in relation to one, payment must pass beneficial ownership. In relation to the other, it need not. So the short point is construction is key. It will be a key component of the revenues focus when presenting with facts involving a mistaken transaction, and the tribunal and the appellate courts if one gets that far. Therefore, it is appropriate that that sort of really close analytical work, I would suggest, be done early in order to put one's client in the very best position to deal with any such situation. That's the first point. The statutory provision really matters. Point two, substantive or realistic view of the facts. If one places that first point in a broader context, one gets a second key point that I would make today. And here the key terms are substance or realistic view. The relevant broader context, which I'm referring, is the Ramsey vein of authority. That starts with a strong contender for the most influential judicial decision in tax case law history. Speech of Lord Wilberforce, formerly of these chambers, in Ramsey, 1982. Ramsey was not a case about mistake, but its influence is hard to overstate, and at the risk of vandalising over 40 years of case law flowing from it, what bubbles to the surface at the end of the day is this. The ultimate question is whether the relevant statutory provisions, construed purposely, were intended to apply to the transaction viewed realistically. That's the formulation in the Hong Kong case of Arrowtown, 2003, franked by the House of Lords and the Supreme Court on various occasions since. So two elements to the Ramsey approach. Number one concerns the legislation, relevant statutory provision construed purposely. We've looked at that. Element two, transaction viewed realistically. This is the second point. In essence, the position is this. If you're dealing with a scenario involving a mistake and the potential tax consequences, it's crucially important to adopt a substantive, realistic, real-world view of the facts. Again, in my experience at least, that is in effect a sort of litmus test the revenue will apply, and it's key, a key consideration for the tax tribunal and the appellate courts. Now, that's not to say that establishing what counts as a realistic or real-world or substantive view is necessarily easy or uncontentious. What does real actually mean in this context? I mean, that's a question I've heard raised non-rhetorically in court on a number of occasions. What does real actually mean here? But I would suggest that, difficult though it might be, it's the analysis which makes naturally falls to be described as realistic, real-world, substantive, non-artificial, that is ultimately most likely to prevail. I said a few words a little earlier about the case law regarding payment in relation to statutory construction. An extension of the same case law illustrates this point. In the Court of Appeal case of Gareth Clark and the Revenue, 2020, in which I appeared, the facts concerned a composite set of arrangements, which, like Hillsdown and Venables, included a pension arrangement. At the heart of the case was the question of whether whether a transfer of money made within the structure should not have been made, and therefore whether it constituted a payment, an unauthorised payment within the scope of the Finance Act 2004. On this occasion, the view of the court was that whether beneficial interest passed or did not pass was not the key question. Rather, what was required was an unblinkered, heavily fact-sensitive approach. As the Court of Appeal put it, the question whether a payment is made for these purposes should be answered by looking at the practical business reality of the transaction, including any composite transaction of which the payment forms part. So practical business reality, any composite transaction taken into account, and don't worry too much about whether beneficial interest passes or not. That's not to say technical and or formal arguments can't succeed, but it is to say that if your analysis allows you to plant your flag on the hill of substance and reality, then that's a good thing. So just as the precise analysis of the legislation matters, so too the narrative of the facts really matters. Can you get comfortable intuitively, it's a matter of common sense, with the story? If you can, then it's always a good sign. Third point, settling with the revenue. If you're looking to reach an agreement with the revenue and avoid litigation or avoid a final hearing, then it's important to keep in mind what the revenue can and cannot do. If one's dealing with a dispute between two private parties, then ultimately the question of whether or not to settle is a matter for those parties. Largely, perhaps entirely unfettered. It is a pure commercial decision. That's not the position when it comes to the revenue. Yes, they have a degree of discretion under the collection and management powers, but it's limited, and it's important to be aware of that. The online guidance in relation to this is actually quite helpful. I know that many of you will know this stuff off by heart and read it before bed every night. But for those of you who don't, I would recommend a bit of time spending time with the material. 2 items of homework I'd suggest. Have a look at the Revenue's online guidance headed Collection and Management. It's not very long. It starts at ASML 3100. It's useful and digestible. Number 2, have a look at the Revenue's Litigation and Settlement Strategy, known as the LSS, and related commentary. Again, it's available, it's online, it's pretty easy reading. The reason I think it's important to be on top of this point when it comes to mistake cases is this. Facts in mistake cases do sometimes, superficially at least, appear to point to a fair or reasonable or commercial, in inverted commas, way to deal with the situation. But whether any such way forward is viable from the point of view of settlement with the revenue will depend upon how it does or does not marry up with a sound legal analysis. 2 quotes illustrate the point. From the collection and management guidance I referred to, HMRC must apply the law correctly, and the commissioners cannot choose to move away from this position merely because the result seems fair or unreasonable. Worth keeping in mind. And from the litigation and settlement strategy, again, the same point really. For all disputes, irrespective of how the dispute is resolved, the LSS makes it clear that the resolution of the dispute must be in accordance with the law. This applies both to the amount of tax agreed and the rationale in law as to why and when that tax is due. Revenue is unlikely to agree terms of resolution which do not conform with correct tax treatment or published guidance. That's the third point. And I say it marries up with the first 2, because if you construe the legislation purposefully and carefully, and if you've got a realistic view of facts, then you probably are in that sort of legally sound space where you can have a sensible conversation with the revenue and find out where the wiggle room might be for a deal. Final point before Robert stops me, tax avoidance. Now this is more than a point really, it's a PhD or a hardback book, but in sort of 2 minutes, I would make the following observations. In Pitt and Footer cases, Lord Walker said this at 135. In some cases of artificial tax avoidance, the court might think it right to refuse relief on the ground that discretionary relief should be refused on grounds of public policy. Since the seminal decision of the House of Lords in Ramsey, there has been an increasingly strong and general recognition that artificial tax avoidance is a social evil, which puts an unfair burden on the shoulders of those who do not adopt such measures, but it's unnecessary to consider further on these appeals. Now, that was said more than 10 years ago. My own observation on the intervening period is that the tax avoidance related case law does not read as a deluge of people picking up the social evil baton that Lord Walker trailed. Submissions along the lines of, this is tax avoidance, therefore it's bad, therefore the court should exercise any discretion against it, tend, in my experience, to fall flat. And equally, sometimes the, yes, this is tax avoidance, we make no bones about it, and it works, can be effective. It happens. It's quite a good strategy. And I mean, there's actually a serious point there, because I think the judges get uncomfortable with something too wishy-washy. They really want to try and get there by the legislation, and this is really the point I wish to bring out. It seems to me, although one hasn't got this exercise of discretion, social evil dynamic going on, what one does see is the extreme potency of the approach to statutory construction advocated in Ramsey becoming increasingly evident. 2 points, 2 cases illustrate the point. Rossendale 2021, Altrad 2024. Rossendale, a business rates avoidance scheme, one of the Supreme Court's most recent statements on Ramsey. Lords Briggs and Leggett, I won't say what Robert said about them, he might in a moment, said this, The result of applying the purposive approach to fiscal legislation has often been to disregard transactions or elements of transactions which have no business purpose and have as their sole aim the avoidance of tax. This is not because of any principle that a transaction otherwise effective to achieve a tax advantage should be treated as ineffective to do so if it is undertaken for the purpose of tax avoidance. It is because it is not generally to be expected that Parliament intends to exempt from tax a transaction which has no purpose other than tax avoidance. As Judge Hand in the US case of Gilbert put it, if the taxpayer enters into a transaction that does not appreciably affect his beneficial interest except reduces tax, the law will disregard it. We cannot suppose that it was part of the purpose of the Act to provide an escape from the liabilities that it sought to impose. Now, it's pretty strong stuff. It formed the focal point of an exchange I had with the Court of Appeal in a case called Altrad last year. And if you read the decision in Altrad, you will find at paragraph 40, Lord Justice Henderson discussing this very passage of Rossendale, acutely sensitive that he'd reached a different view from the Supreme Court in Rossendale. Anyway, where he landed is this. It seems to me that the Supreme Court here comes close to enunciating a general principle which should be applied to the interpretation of all UK tax legislation, i.e., it's not generally to be expected that Parliament intends to exempt from tax a transaction which has no purpose other than tax avoidance. So my observation would be that while the courts tend to be reluctant, despite Lord Walker's encouragement in Pitt, to found their decision-making, at least expressly, on a simplistic tax avoidance is bad proposition, and analytically I think that must be right to not go that way, they are perhaps increasingly slow to accept the validity of a statutory construction which potentially facilitates clear passage for a tax avoidance scheme to achieve its intended aim. So I end with a question. Is it the case, as the Court of Appeal at Altrad suggests, that a new general principle in this area is emerging? Answers on a postcard or perhaps in a tweet, please. Perhaps an article or a case needs to explore this point further. Thank you.
Finally, I'm going to say something about the actual remedy of rectification. Knowing that I was coming last, I predicted that I wouldn't have my full share of the time, and it hasn't been a complete misprediction, though actually we've done rather better than I expected. I have, however, felt we've had the ghost of Lord Millet with us. He and Lord Walker both having departed this life. Lord Millet will be taking Lord Walker on one side and saying, misprediction, I told you Gibbon and Mitchell was right. Rectification, 2 points I want to make. The first is to draw attention to a case which bears on formalities, which is a pension case about the Radley College Pension and Assurance Scheme. Though there is a typo in the report on Bailey, where it's referred to as the Radley Collage Pension Scheme. And what happened there is that somebody signed in the wrong signature block. And so there wasn't the correct execution. And for the first time ever, I think, the court rectified a signature block by changing the basis on which this individual was signing. The case has a connection with Wilberforce Chambers because Thomas Seymour, who used to be in Chambers, was chairman of the trustees of the scheme at the time. And since the judgment appeared last November, Thomas has sadly retired from Chambers, but it's not because of his involvement in the pension case. The second case I want to draw to your attention is a case called Tyne and Ware Passenger Transport Executive and RMT Union. There's long been a debate about what the position is where you have an instrument which is rectifiable, but there's not yet been an order for rectification. Broadly speaking, there are two views. One is that unless and until a court of competent jurisdiction has made an order for rectification, the instrument takes effect according to its terms. The opposite view is that because equity treats as done that which ought to be done, it's unnecessary actually to obtain an order for rectification where the requirements are satisfied. And over the years, one has seen many opinions taking a stance on this issue. In some cases, the same writer taking both views. I have in mind opinions of Edward Newchie, which were never full of much doubt, but I've seen dogmatic opinions from him, both sides of that line. It's a point which has some significance in the context of tax, because the tax tribunals, like the common law courts before the Judicial Acts, don't have jurisdiction to grant rectification. An issue of this sort arose in a case called Lobler and the Commissioners about 10 years ago, where Jonathan appeared for the Crown. It was about the chargeable events legislation, where it's notorious that the way in which money is taken out of policies can lead to very different fiscal consequences. It was a real hard luck story. The taxpayer had effected the policies without any tax avoidance motive, needed to take out the money, got the insurance company to send him a form which offered 4 options, and without taking any advice, ticked the wrong box, and so exposed himself to a charge to tax which was both unnecessary and potentially ruinous. Sitting in the upper tribunal, Mrs. Justice Proudman held that the forms could be rectified, and on the basis of the equitable maxim that it was unnecessary for there to be an order for rectification if the requirements for rectification were satisfied, as she held that they were. If you read the judgment, you may be left with some doubt whether the requirements for rectification were in fact satisfied. But for the point I'm concerned about, she opted for the equitable maxim point of view. This is an issue which has now been settled once and for all by the RMT case. The main point there was whether the court could rectify a collective agreement that was not itself legally binding, but had been incorporated by reference in individual contracts of employment. The Supreme Court said that since equity did not act in vain, a court would not usually grant the equitable remedy of rectification if a document didn't record legally enforceable rights, or obligations. But there was an exception if rectifying the unenforceable document would itself give rise to legally enforceable rights and obligations, then it could be rectified. Now, in the Court of Appeal, there had been divergent views on the issue I'm concerned with. Lord Justice Underhill accepted that the tribunal, and the issue that was discussed was whether the employment tribunal could take account of rectifiability. Lord Justice Underhill held on the basis of a statement in Snell and a couple of 19th century cases, the rectifiability was available as a defense, a shield, not a sword. Lord Justice Newey rejected that idea and held in accordance with what he considered to be the conventional view that there had to be a claim for rectification, and that until there was an order for rectification, the instrument took effect according to its terms. Lord Justice Males held that the tribunal did have power to order rectification if it was necessary to determine a claim within its jurisdiction. In the Supreme Court, the only reasoned judgment was given by Lord Leggatt and Lady Simler, and they didn't accept the views expressed by any of the members of the Court of Appeal. They rejected an idea that the two 19th century cases should be interpreted narrowly as decisions of on the effect of the Judicial Act. In their view, those two cases could be viewed as authority for a general principle which accords with equity and good sense. If it's clear that because of a relevant mistake, a document does not accurately record the true position between the parties to proceedings, a court is entitled in determining their mutual rights and obligations to treat the document as if it had been rectified without the need to make an order for rectification. And they identified a number of cases where that principle had, they said, been applied. Their conclusion was that where the conditions for rectifying a document were met, it could be treated for the purpose of determining the party's rights as rectified without a formal order for rectification. Now, there seems to be no reason why this should not apply before the tax tribunal. And so the decision of the Supreme Court in this case can be regarded as a vindication of the decision of the late Mrs. Justice Proudman. That's all I had to say. We've got a few minutes for questions, if anybody has any. But I will rise to the bait of what Jonathan said about Lord Briggs and Lord Leggatt, which is not something I said, but someone who'd been sitting with them in the Privy Council said to me at the time that those two are out of control. Look at their judgments and think about that. So with that thought over in your mind, any questions? No. In that case, I'm going to say one last thing. Jonathan Davey has been nominated for the City Wealth Magic Circle Barrister of the Year. Voting is still open. It closes, I think, at the end of next week, fairly shortly, but after this morning's performance, I'm sure you'll all be going back to the office and voting for him.
I'll pay you later, Robert.
Thank you very much.